know that. There we go. Good morning, everyone, and welcome to the Government Operations Committee. The chair, Nancy Navarro, is not able to be with us this morning, but we do have one item on our agenda, which is to discuss the public ethics law under Bill 1722. There are some amendments that were recommended by the Ethics Committee itself, while others were proposed by other agencies, and this is obviously an important task that must be taken to ensure transparency and to fight corruption. Unless you have any comments, I'm going to turn it over to Ms. Wellens, who we're going to publicly thank once again for doing an extremely good job for this packet. And I did want to welcome Bruce Romer, who's the Vice Chair of the Ethics Commission, Robert Cobb, who's the Staff Director and Chief Counsel of the Ethics Commission, Aisha, who's corrected me several times on how she said her name, and I had to stop and think about it for another time. Aisha Memon, who's the General Counsel for the Housing Opportunities Commission, which is also called HOC for us, and Caitlin McDonough, who's representing HOC. And with that, I'm going to turn it to Ms. Wellens.
Thank you, Mr. Chair. Good morning, council members. Bill 1722, Public Ethics Law Amendments, was sponsored by the Council President at the request of the Ethics Commission. It was introduced on June 21, and a public hearing occurred on July 26. The background on the bill is that it is an attempt to achieve several goals. One was to clarify that certain ethics provisions of the procurement code would apply to certain agencies that do not normally fall under our procurement code, including the Housing Opportunities Commission and the Montgomery County Revenue Authority. The bill also would make updates to the law that have been requested by the state in order to more finely align with the state ethics law, including altering the definition of restricted donor and adding a definition of quasi-governmental entity. The bill also would expand the scope of financial disclosures and would explicitly prevent reprisals against employees for their cooperation with the Ethics Commission. Subsequent to the introduction at the public hearing, we heard from Mr. Cobb on behalf of the Ethics Commission, raising a couple more issues for the committee's consideration, including that they raised an issue about potential conflicts of interest that can be inherently created when an individual from a certain stakeholder group might be appointed to our advisory boards, committees or commissions. And we'll discuss that issue for you. In addition, they recommended some amendments to specifically require financial disclosures from appointees to the Police Advisory Committee and Administrative Charging Committee, and recommended mandatory training for BCC members regarding the ethics law. So to jump into the first issue, you received comments which are included within the packet at Circle 50 from the Housing Opportunities Commission, expressing some concerns, and which they're here obviously and they can better articulate themselves, but the summary of the concerns was that by placing HOC under a provision of the procurement law, that this could potentially create confusion because they are not otherwise subject to the procurement chapter of the code. And they noted that there are multiple conflict of interest protections that exist regarding HOC employees already, and also they noted this would place burdensome procurement restrictions on third-party vendors that they work with. Council staff's understanding, as I was best able to boil it down, although folks can further explain to you their positions, but my understanding is that the HOC is currently using a form contract that essentially includes within it the same provisions that exist in the ethics code, in the procurement law, that prevent a vendor from soliciting an employee from the HOC or whatever entity it may be to work for them, when the employee is significantly involved in a procurement matter that the vendor is a party to. And under their their contract template, then the waivers can be obtained in certain instances, and those waivers can be obtained from the Housing Opportunities Commission itself. So my understanding is the difference would be if they're placed under the procurement law pursuant to the bill in this narrow capacity about the vendors, that the difference would be that then the Ethics Commission would be the one to review and decide upon any waiver requests as opposed to HOC. Council staff is concerned about avoiding any confusion under the code of, HOC needs to be clear what requirements they're subject to, what requirements they are not. I've laid out a potential amendment that I think would help clarify that HOC and these entities that are not normally covered by our procurement law, including HOC, would just be subject to this 11B52A of the procurement law, which is the part about vendors not soliciting employees. And the reason I think a clarification might be helpful is that under 11B52, I'm sorry, I think I'd said 11A52. Under 11B52, the ethics portions of the procurement law, there is not only an A, but there's a B, C, and D, which really would not be applicable to an entity like HOC because they involve, the authority, being subject to the authority of the chief administrative officer, for example. I think that gives you the background, sorry.
Well, just so the amendment that you're suggesting is on page 3 of your packet, correct?
Correct.
Yeah. And I'd like both the HOC as well as the ethics group to comment if you'd like. Good morning, please. There you go.
Good morning, Mr. Chair and members of the committee. Caitlin McDonough with Harris, Jones & Malone representing HOC today. I'm happy to kind of provide some background on our comments on the bill generally, or I can address the amendment.
Do you disagree with the background that she?
No. I mean, okay. just for a matter of clarification, I think council staff outlined it very well. I think one of our biggest concerns, as council stated, is us starting to get drawn into the procurement process or the procurement statute. So I think the amendment included in the packet does help address, kind of clarify what provisions we would be subject to and what's not. Another suggestion we might proffer, just from kind of a drafting standpoint, would be to duplicate those provisions for the county agencies that this would now explicitly apply to, but to move it to 19A of the ethics code, which is where all the other provisions that we're currently subject to are. From a drafting standpoint, from a compliance standpoint, we think it makes it more clear. And we do think it addresses that ambiguity that we wouldn't be subject to the others. That is something we've raised with the commission, and if they're agreeable and the committee's agreeable, that may be an alternative drafting solution to address that. So the provisions would substantively be the same, they would just move. The only other kind of addition that I think we'd want to make today is I think we understand the commission's concerns and we wanting clarity around the solicitation, the point, what the conflict of interest concerns might be at that point. The only other suggestion I think we'd ask the committee to consider is, because our vendors are not generally subject to the county's procurement law, I think we have some concerns from a compliance standpoint that they may remain unaware of this. So what we would suggest is, and obviously we would do our best to educate them, but that the trigger at solicitation would be on the employee being solicited rather than the vendor. So if you're approached by a vendor and you have concerns that there may be some overlap in your previous work, that it would be on that HOC employee, who we know is already bound by the Ethics Commission and ethics training, to alert and inform the Ethics Commission and initiate that waiver process. Similar to what they would do for employment, but at the point of solicitation. We just think it's more consistent with our current process, and you know, again, from a compliance standpoint, we think it's better for employees to do that. I do understand that's different than what's in place for other county employees. I don't know if that's something that you want to consider for other county employees, but you know, if it's the will of the council to explicitly make HOC subject to that we just think from a compliance standpoint, it's better for the trigger to be on the employee rather than the vendor. And I don't know if Asha has something to
Yeah,
add.
I can add a couple other points to that.
Good morning.
Good morning. So the reason why that also makes additional sense is that the employee would also have to seek its own waiver to accept the appointment. So by the employee going to the Ethics Commission itself and getting the initial waiver to even discuss employment, they could simultaneously ask for the waiver to accept the employment. So it keeps it a little bit more streamlined. And then it takes the burden off of the vendor who, you know, at a certain point, the vendor doesn't even know if the employee's interested in this position. So the vendor has to expend time and resources to even ask the question of the employee, hey, are you interested in this job? And the employee could say, no, I'm not interested. So now this vendor has spent time and resources to ask a question for, in reality, the vast majority of HOC's positions are, you know, we're talking about positions that are paying less than $90,000, which in this county is not a lot. So these vendors don't have the time and resources to be recruiting somebody that works in resident services, somebody that works in maintenance, versus maybe an executive director position.
Councilman Fritz.
Well, sorry, there's still a little bit of an echo. Maybe it wasn't that, but first of all, thank you. I think I'm hoping that we can work together to get to a place where we're addressing the concerns, but fulfilling the goal that the Ethics Commission is trying to put forward, which is to address conflicts, potential conflicts, perception of an appearance of a conflict, which I think is really important. So I'll just start with that. And I'd like to hear from the Ethics Commission on this, but I'd also like to understand, from my perspective, what would, I know what triggers a job. You know, that's a very clear, someone makes you an offer for a job, it has a salary, you know, that is a fairly obvious scenario. A solicitation is a little bit more fluid. There could be somebody saying, hey, there's always a job waiting for you. Is that a solicitation? There could be a scenario where there isn't a job that exists, but if you'd like to work for us, we'd figure something out. You know, the way that I think most people think of a job is that there's an open job in a company and you're being offered the ability to take it, like to lead the company maybe, or to be the vice president of the company, or whatever the case may be. I'm just curious, in a scenario where that doesn't exist, you know, for the purposes of the Ethics Commission, it'd be helpful for us to understand, I think, for this discussion, you know, what would the trigger even be? You know, you're talking about who is responsible for reporting when the trigger happens. I'm interested in what would even trigger the requirement, because, you know, some of the same dynamics that we're talking about here may be relevant to something that's a little bit less specific than, you know, specific job opening, particular offer. Is this something you'd be interested in or not? You know, if so, we'll take it to the next level of an interview, et cetera. So, I mean, it'd be helpful to hear from the Ethics Commission in general, and then on that particular point.
Please.
So let me go in reverse order and address the point first, and then speak generally. With respect to your question about what triggers, I think it's colored by two things that you don't see in this specific provision. One is the general mandate of the Ethics Commission reflected in 19A2 of the law, to interpret the laws broadly to affect the intent of the law. And what's the intent of this provision? and it has a parallel provision in 19A13, post-employment provision. But the intent is to assure the impartiality of government employees in the execution of their government jobs. So, to get to your question of what would the Ethics Commission deem, it's going to look at the facts of any particular case. There would be a notice provision in the contracts, as is done in the county and as HOC is already apparently doing, that contractors may not offer employees jobs to employees who are working significantly on the matter. And the upshot of that is they should ask for advice in connection with what you posit your question.
Who was the they in that?
The they would
discussion?
be the vendor.
Okay.
Would say, because this restriction applies to the vendor, so the vendor should seek advice. Maybe they go through their contracting officer, and the contracting officer puts them in touch with our office. But the ultimate answer is, well, that's a close call. But I think the Ethics Commission would say, no, that's not consistent. The notion of saying there's a job for you here when you want to leave county service would not be consistent with the provision. That's in effect an offer. Now, I can't speak for the Commission. I'm the Attorney's Counsel, and I'd advise them of what I've just told you in terms of the scope of the law and the intent of the ethics law to ensure impartiality of government employees. But I don't think your government employees can be impartial if the person whose contract they're operating says there's a job here for you anytime you want it. So then more generally, just in terms of the landscape of the ask in terms of inclusion of HOC and MCRA in particular of this 11B52A is, I'd say that currently the law is not clear, and the Ethics Commission has had to deal with this as to whether or not it wants to interpret. And the Ethics Commission in Chapter 19A is vested with the authority to interpret 11B52A. And in connection with that, the HOC employees, MCRA employees, are public employees under the Public Ethics Law. And you'd think that all of the provisions that the Ethics Commission is vested to enforce, provide advisory opinions on, interpret, including 11B52A, would incorporate the same class of people, all public employees, inclusive of MCRA and HOC employees. So it raises a question under current law, and really what the Ethics Commission is looking for clarity, and it presumes that the rules that apply to all public employees, all county employees, all board, committee, and commission members, that those same rules should apply to the HOC and MCRA as well, and their vendors.
Go ahead.
Do you have a concern with the moving? Their concern is related to procurement, not really related to ethics. But it seems, and I don't want to misinterpret what I've heard, but it seems that the concern is the slippery slope, not necessarily on this particular issue. I think there are some dynamics on this particular issue that I'll get to in a second. But the first, primary concern is, can we, move this into ethics and move this out of procurement? Is that what I'm understanding?
And just for county agencies that are not subject to the procurement process, which are the three, I think, agencies impacted by this change.
HOC, MCRA, what's the third?
Board of License Commissioners, which I think operate a little differently, but.
Yeah, I think they're already covered by, they don't have the same issues that MCRA and HOC have.
They're
clearly
truly
covered.
independent.
No, they're clearly covered.
Agencies. No, I'm saying the two are
Yeah.
truly independent, and Board of License Commissioners is not to that extent. Is that?
Yes.
Do you have would you believe the Ethics Commission would have a concern with if the language was substantively the same, the location of the language?
The Commission's not going to be concerned about that, and we'll do what, I don't know that it needs to happen, but if the thinking is that it should be in 19A, the Commission would have no problem with that.
Okay, great. And then the other issue, it seems, And I agree, and I'm glad you said, first of all, I'm glad you said what you said, that, I think if somebody says there's a job waiting for you here, that's a standing offer, and you're a future employee of that entity, and you now have clouded judgment, by definition. So I think any plain reading of the intent of the ethics code would clearly, point in that direction. So I appreciate knowing that. The other question is basically, as far as I can tell, is the burden. Is the burden on the employee? Because you talked a lot about these are employees and they clearly should be subject to these issues, or is the burden on the contractor? It seems to me that's the other, the other issue that's being raised here that we should discuss and determine, the most appropriate path forward to maintain the intent.
That's right, and just as
Can you
additional
come a little
color.
closer
Yeah.
to the
Yeah, it's
to the mic?
additional
You
color.
can tilt the microphone.
Yeah,
yeah, there you
sorry,
go.
my height is
Just,
that one.
we can hear you, just to be clear, we can hear you, but that makes
Sure.
sure that those who are streaming and watching.
Zillions of people at home.
Yeah.
The other issue that I was going to bring up is that the solution that we're proposing is more akin to what exists in federal law, that the onus is on the employee instead of the vendor. So I do think that it also adds additional clarity since we are subject to federal law and our procurement policy incorporates federal law. So it would be a little bit more streamlined for HOC. And I know some of the questions are, why is HOC different than other county agencies? And this is one of the reasons, is because we have to incorporate federal law, state law, and county law into our procurement policy.
Ms. Wellens first, and then let's go to
I'm
the
sorry,
ethics
I just
commission.
wanted
That's
to
okay.
note that
Okay.
under the current 19A, the onus is already on the employee. And so it's both. The onus is on the employee, and the onus for county procurement agencies, the onus is also on the vendor. So it's dual responsibility.
Yep.
So if I'm not sure exactly how it would work, but I think under this proposal, if it's just the burden on the employee, I'm not sure that's really a change from existing law.
I would disagree. I think it is a change because now, as an employee, not only do I have to report if I'm considering employment, but I have to report that I've even been given an offer. So the Ethics Commission's getting the same information under both versions of the law, right? Under the ethics proposal, the vendor is sending the information, and under my proposal, the employee is sending the information. But the new information is being received by the Ethics Commission one way or the other, but now you're getting it from the employee who fully understands their responsibilities because they go through county's ethics training at employment and every 3 years.
The difference is timing. And I'd like
Timing
to hear from the
and
ethics commission.
education.
The difference in the case that you were talking about is timing. So if the employee is reporting once they've been made an offer, they've been made an offer.
Sure, but at least
by definition, if the vendor has to request permission to make an offer, the permission has to happen before
but
the
now you're
the
armed
offer is
with
made.
the information of whether the employee even wants the job.
But-
At the start, you don't even know if the employee's interested,
But
and so the vendor.
Is that
I think it.
Can we hear from the ethics commission?
Yeah, I don't know.
To me, the solicitation of an
Yeah.
employee, the employee's interest in the job is not relevant. Once the employee has been offered a job, whether they're intending to take it or not, that solicitation has occurred. If somebody asks you to go out for dinner, you have asked them on a date whether they say yes or not. Unless I'm missing something, the solicitation exists with or without an interest from the solicited. Could we hear from the Ethics Commission?
So, Councilmember, you're correct that the milk is already spilt as soon as the solicitation is made, and the provision, and it does vary from the federal procurement regulations as represented, but this is the requirement that applies to all county employees. On the notion that the HOC is somehow different, I'm hearing that they're saying that they're subject to federal procurement law, and I don't believe that's the case. They are subject to the Montgomery County ethics law, and The question is whether or not to treat them differently than every other county employee and BCC member who are public employees.
Could I ask one more follow-up
Sure.
question to this? So if your main concern is the nature of the relationship between your vendors and the Ethics Commission, your employees currently interface with the Ethics Commission, they have to file reports, they are subject to the same standards as we're talking about. We're now expanding that not just to jobs, but job offers, essentially solicitations of jobs, and you've not expressed a concern about that part related to the employee. Could I ask the Ethics Commission is there any reason why a vendor couldn't go through HOC to request permission from you? And so I say that so they currently, from what I understand, currently have a standard where you have to request permission from the executive director. So of course, for any employee other than the executive director, that is some level of reporting standard. If the executive director in that case were to forward the concern, or forward the request to the Ethics Commission, would there be any concern about that as a process to fulfill the requirement?
I'm confused on what we're asking at this point. So you're saying if a vendor had, I'm asking now,
Yeah.
had solicited and said, there's always a job here for you, at that point, the employee would go to the executive
No,
director?
it's not take ethics commissions and laws out of it, right? In a normal circumstance, it
can,
wouldn't
but
be,
you-
no, for a minute, just
Yeah.
in a normal circumstance, it wouldn't be odd for, you're doing business in the private sector with somebody and you want to poach one of their staff members because you think they're talented. As a courtesy, you call the CEO of the company and you say,
Yeah.
hey, listen, we've been working with so-and-so. We think, that person is great and we're going to make him an offer. And I just want to give you a heads up so you don't think we're, doing something untoward, or I wanted to get your blessing, or, whatever the case may be. That is, presumably that happens all the time. Like, that's not an odd thing. In this case, there's an ethics dynamic to it because we're dealing with public dollars and public funds. But the same standard would apply. You're basically calling and asking for permission before you approach the employee. The question is, would that be an issue if the standard was that you need to get permission from the Ethics Commission, and instead of the company calling the Ethics Commission directly because they've never dealt with the Ethics Commission, that they deal with HOC, and that's written into their contract? I'm just asking the question of whether that would satisfy the requirement that you are setting forth. Like, would there be any issue with HOC sending you the request from the vendor versus the vendor coming to you directly?
So really, the way I'm seeing your question is, I see your question as one of execution rather than of law. That would be fine with the law as is recommended by the Ethics Commission here. We have an expectation that contractors would see the prohibition that's in their contract, and they'd say, okay, what do I do now? Then bring it to the attention of the contracting officer and say, we want to offer so-and-so a position, or take it up to the director of the agency, whatever comfort level they have, and those persons would say, oh, well, you need to get a waiver from the Ethics Commission in connection with this. I'd be happy to
So to you, it's a
correspond.
distinction with that. It would be to me. I just wanted to make sure that there's no issue
Yeah,
with that.
that's correct.
So what's the? I'm just trying to then understand the concern of HOC. If you already have a standard where you have to get permission from that you write into your contract, language that has already been discussed, my understanding, and it says you have to go to the executive director to request permission. It's essentially the same. Isn't it the same thing that if you went to the executive director, the law says that you have to go to the Ethics Commission. Here's how you go to the Ethics Commission, or I'm happy to forward along, this request and put you in contact with Moose Cobb, the counsel for the Ethics Commission. I'm not sure I'm understanding what the.
I mean, I certainly,
the major
I don't want
changes.
to ask a question. I guess just for a clarification point, I think from a compliance standpoint, what I would want to be clear, and maybe this is in the contract language and not so much in statute, is the executive director or human resources, whoever's kind of point at HOC, then making a determination of whether it goes to the commission or not?
You should.
But I mean, I believe the waiver only triggers if someone has determined, whether it be the vendor or HOC, that there's substantial involvement. So I mean, you could approach anyone at HOC if there's no substantial involvement. There's no legal requirement that you get a waiver if there's no relationship.
Well, I'd like to hear from that. My perspective would be if you're
Is it
actively in
automatic?
procurement with the agency and you're looking to poach their staff, you ask for
But
permission, and then the Ethics Commission determines whether that person has been, substantially involved. Is the general, to your point, is the general counsel substantially involved in a procurement? Well, if they signed the contract, I would say that yes, they absolutely. If they reviewed it, if it's somebody who's in a completely different department who didn't even, had no awareness that the procurement was occurring,
Would the vendor even need
perhaps
to
not.
ask?
But I think that's, that's a. I wouldn't want that judgment call to be made by the CEO or the executive director. I'd want it to be made by the Ethics Commission.
Well, I think right now it'd be made by the vendor.
Right now,
That's correct.
if in the contract, I guess this has gotten more confusing than it needs to be, but right now, if it's in the contract that the vendor cannot make a solicitation for a job for the person they're negotiating with, if that happens, what happens at that point? Who reports that they did it?
Right now, the way the contract is written is that the vendor would have to seek approval from the executive director to offer employment.
So in the
Right.
contract, it says that they could say, there's always a job here for you. And they wouldn't have to, because they didn't actually offer a job.
Well, I guess we're getting into like the definition.
No, but
of
I think this is the
solicitation.
practical side of this.
Sure, I think that whether this lives in a contract or whether this lives in the legislation, I think definition of solicitation would be useful. Instead of having to go to the Ethics Commission every time to figure out what was a solicitation. So I think, the point is, I think, valid. We need to have a definition of what that means. But that's true any way we go.
And my other concern is that there is no, I'm asking here, but that there's no guarantee that it would be in the contract. I mean, the fact that it's in each contract is one thing, but I do believe there should be a guarantee that you can't do this. I mean, that's what ethics is all about, is you just can't do this. So, yeah.
So at this point, I think HRC's position is not we are against having some form of legislation out there that addresses this issue. What we're arguing about is what is the best solution to the problem. And we think that what's being proposed isn't the best solution because of the unnecessary chilling effect for the vast majority of employees, where those employers don't have the time and resources to constantly get in contact with the Ethics Commission to ask, hey, what's a solicitation? Okay, now I'm going to solicit, can I? And then have the employee have to go to the Ethics Commission and say, hey, can I get a waiver to work here? So I think it's just truncating the
Yeah.
process.
I'd like to go to Moose Cobb for a second, but before I do, I mean, how common is this? I mean, the way that you're describing it is if like every day vendors are soliciting and offering jobs to HOC employees, and this would create a massive undue burden on vendors to have to almost on a daily or weekly basis request permission from the ethics committee. I mean, is that because
Because
that might strengthen the ethics commission's
This is-
point here of why a standard like this is needed, to be perfectly honest. But
This would be a new requirement, so we obviously don't have any data on it. But I would say that in general, the difference between HOC and the county is that we have a procurement team of 5 people. That means every single department is expected to participate in procurements. We have panels going on at any given time, 15 different procurements, and we have every department sits on a panel. So you, by that definition, are significantly participating in a number of contracts. So the exposure to an HOC employee is broader than it would be at the county. So I would just say, yeah, maybe the overall numbers aren't high, but proportionately to the county, I would say it would be higher.
Right, but I mean, the flip side of that argument is that exposure to risk that the Ethics Commission is trying to solve is also higher, and
It
so
depends, right?
there's a
So
proportionality.
You have a maintenance worker or a resident services worker scoring a property management contract, where in reality, after they score that contract, they have no involvement with that contractor. They don't see them or talk to them or interact with them for 4 years, but yet now they're under this law. So it's the definition of significant participation, which is in the code, is extremely broad. So it would have an impact, and I don't think it would be a necessary impact, right? Because that person probably doesn't have an ethical conflict to accept that employment, but yet they would still have to go through all these hoops.
Could we hear from Mr. Carl, please?
Please.
So the term significant participation is defined in 19A13, I think it's C of the county's ethics law. And what I think I'm hearing is that what the HOC would like is for themselves to be able to interpret what that means in connections with questions that arise under that provision, rather than have the Ethics Commission make determinations of what that means. I'd say that would be the only instance where the County Ethics Commission would not be the authorized entity to interpret what the ethics law means in given cases, and I think the Ethics Commission would object to that proposal.
Okay.
It's like when I was growing up, you know, some days you got to check your own homework, and some days you had to turn your homework in, and most people were very happy when they got to check their own homework. So I'll just say that. So just to put my cards on the table here, I am open to moving the location of the language. I think that was a reasonable request. It doesn't seem like there is an objection from the Ethics Commission, but beyond that, I have some real concerns about what is being requested here, and don't think that we should essentially limit the ability of the Ethics Commission to do what the Ethics Commission is empowered to do. So that's where I'm at. Thank you.
And I'm playing with those same cards. I'm good with that. So basically, Ms. Wellens, have you gotten what we're saying at this point?
Yes, Mr. Chair, my understanding is that you would like this provision moved to the Ethics Code to 19A instead of incorporating it into the Procurement Code. The Procurement Code would remain as is. So I will just need to wordsmith that for you and can bring it to the final council.
And HOC is shaking their head yes, so okay, very good. I guess we have next topics on this, please?
Yes,
Just
thank you,
for those
Mr.
who were
Chair.
watching, this was the most difficult, I guess, or the topic that was going to cause the most discussion. Yeah.
Yes, I think there was the most to unpack, and perhaps these issues will be more straightforward, but you never can tell.
Yeah,
So
no,
we
it
have
is
a,
Montgomery County. Yeah.
The next issue was brought to your attention by the Ethics Commission related to board, committee, and commission BCC appointees. As you know, there are many BCCs in the county, probably over 80 of them. The vast majority are advisory groups, not groups that make final determinations on behalf of the county. So the potential concern is arising if there is a member of a stakeholder group who is appointed to a commission, and the commission in some capacity is, for example, making regulations or recommending regulations that directly impact the stakeholder group, and the kinds of conflicts that could potentially bring up. The Ethics Commission suggestion, as I understand it, and that seems eminently reasonable is that going forward, and also perhaps it's a matter of technical corrections to the existing code, that whenever there's a representative of a stakeholder group, that we make very clear in the language that the member is a representative of the stakeholder group. So, you could say that's an inherent conflict of interest, but the reality is you need the expertise and contributions of some individuals who are in, an affected industry or a stakeholder group. It just needs to be clear who they're representing. So that's, as I understand it, the Ethics Commission's suggestion. If the committee agrees, you could direct staff to do that, and I'll make sure it's reflected in the minutes and carried out.
And that's a 2-0 at this point, yes, okay. And, yeah, go ahead, please, Ms. Scott.
It's a complex issue because you get into circumstances where you use the word represent and you don't know exactly what it means. It doesn't mean they're from a group or that they're there actually to represent the group. And this came up in connection with the Building Performance Improvement Board, and in connection with that particular entity, it may be that there needs to be technical amendments or amendments to their statute so that people who are appointed to the board can take the actions that I believe council intended them to take without concern for conflicts of interest or having to come to the Ethics Commission for a waiver.
Okay.
Yeah, it's interesting because there's two different dynamics here. I think it's important to note. One is where you literally are representing an organization. So I chaired the Collaboration Council for Children, Youth, and Families. Actually, Gabe Albernas chaired it before I did. I chaired it as a member of, well, it's called a private member, but as a member of the public at large. Now, I may have been checking a box of representing a part of the county geographically or a demographic that was intended, but I was there as a private resident of Montgomery County. Councilmember Albernas, before he was Councilmember Albernas, was Director Albernas, and he was there representing the Recreation Department. He was there as an official on behalf of the Recreation Department. And so he was clearly representing. And so I think the dynamic that we're going to have in some of these, including what you're suggesting, is, for instance, if we have a building performance committee or some other dynamic, we could have standards that are set up that say some need to represent large companies, some need to represent smaller companies, to get a representative dynamic of the county. And then the question is, are you there representing a specific company? Are you there representing a set of companies? And so I think that's what's going to have to, I'm assuming that's what's going to have to get worked out. The rec department that Gabe Albernas was representing is very obvious and clear. You're there in an official capacity. Some of the other representative dynamics are a little bit more nuanced.
Exactly. Are you representing the public interest, and is that your obligation, in which case you can be covered by the ethics provisions, or is your duty of loyalty to a particular constituency that you're representing in your participation on a particular entity?
Right. Okay. Thanks.
So, please, Bruce, did you?
Only that, in addition to being an individual representative of a person on some of these boards is there to represent an entire industry.
Right.
Yeah.
Okay.
Yeah. So we're good with this one. Ms. Mullins, we're good with number 2 decision point.
Thank you. Number 3 decision point relates to clarifying under the bill that Police Accountability Board members and Administrative Charging Committee members must file financial disclosure statements. And I'd like to ask, if I may, for Mr. Cobb's help with this one to ensure that the language that I've suggested here is making the necessary clarification.
And just for those who might be following this, it's on page 4 of the packet.
And from our perspective, the language is fine.
It's fine, okay. We're good? Hmm?
Yeah.
We're good.
Okay, thank you very much. I just wanted to double check on that one. And finally, the final issue that's mentioned in the packet for your consideration, I'm at page 5 of the staff memorandum, item number 4, training of BCC members, board committee and commission members. The Ethics Commission has recommended that the bill be amended to explicitly require BCC members to be trained in the public ethics law. There's an amendment there for your consideration.
And we're good, and you're good with that as well. And with that's without objection as well.
That wraps it up, Mr. Chair.
Anything else? No. Thank you all very much for all your work and for doing everything you're doing. We are adjourned.
So just, but,
Oh, wait.
and then just to clarify, very
Okay,
sorry.
we're not
I shouldn't have
adjourned.
said we are wrapped up in quite the way I did. So just, I take it that it's 2-0,
Oh, yeah, it's a
recommending
2-0,
enactment with the
yeah,
amendments.
yeah.
Yep.
I assumed that, but
Yes,
should
I
know.
assumed it too, but just
Yeah,
thought
no, I appreciate that. And we're
Thank you.
still okay. We are adjourned. Thank you.
Thank you very much.
Thank you, council members.